Thank you for coming this evening. Welcome everyone to the Kingston Senior Center. We're happy to have you. I'd like to introduce to you Kate Federoff, our General Counsel on all matters marijuana, most matters zoning. So she'll be a wealth of information. We ask that you be recognized once you raise your hand, and when you are recognized, please come to the microphone and ask your question. And then Kate will do her best. If you can't hear the question that's asked, then just turn around and you can say it again to the audience if they didn't hear you the first time. So we welcome you. We want this to be an open exchange of information. Kate is a wealth of information. She can explain how the recent court ruling impacts our articles, and perhaps if we have a very successful night, everyone will walk into town meeting with a clearer understanding of what the articles are and how they impact us here in Kingston. So with that, I'd like to turn this over to Kate Federoff. And Kate, we appreciate you coming down tonight to enlighten us.
Thank you. Thank you so much for having me.
Here we go.
Oh, how about now? No.
Oh, so I just spoke loud.
Oh, okay. Can you hear me in the back? Do you want to move to
There are
these
empty seats up here.
Move forward, and I'll try to. How about I'll try to project a little bit too? Can you hear me now? Okay. Thank you so much for having me tonight. And again, as Tom explained, I've been asked here to discuss marijuana because there are several articles on the warrant for this town meeting, and some of them are accomplishing or attempting to accomplish different things. So what I'd like to do is, before I get into the articles themselves, I'd like to talk a little bit very quickly about 94G, which is the legislation that controls recreational marijuana, and what, in a really encapsulated way. And what 94G provides is that municipalities can regulate marijuana or prohibit marijuana. And the method of prohibiting marijuana is not clearly spelled out in the legislation. It doesn't expressly say it has to be by zoning bylaw or general bylaw. Initially, when Kingston first thought about dealing with marijuana, it adopted a moratorium. And then, and I forget the date when it was, I want to say it was a year or a year and a half ago, when we tried to extend the moratorium, which is a zoning article, to allow us to figure out what we really wanted to do in the town of Kingston. That moratorium failed. So what we did was we went ahead and we quickly created a zoning bylaw and presented that at a special town meeting, right, Elaine? A special town meeting, and that successfully passed. And what that zoning bylaw did is it allowed marijuana uses in certain areas of town, and it set buffers, et cetera, all of which is very permissible in 94G. Now, what we had as a firm initially advised our clients when we were dealing with 94G is we said, if you're doing a prohibition, it makes sense to do it in a zoning bylaw. And why did we make that recommendation? It was because the AG gave us this advice. So what happened in, I believe it was the town of East Bridgewater, they had done a prohibition by a general bylaw. And the AG, when it passed at town meeting, the AG approved the bylaw, but there was an admonition at the end of that AG's decision, which said, be careful, we're approving this bylaw, but there's other case law which stands for the proposition that if it looks like a zoning bylaw, it regulates uses, it might not withstand judicial scrutiny. So if someone appealed or tried to cite and you denied them based on the general bylaw prohibition, perhaps they could appeal to the court and successfully say your bylaw wasn't adequate prohibition. So that's what we had told our municipal clients, but in Kingston we regulated the use. Now, since that time, and of course with any new type of use, we struggle to meet different address moving targets, right? And recently, it was just in the spring, in March, when this very issue came to the land court. And in that case, what happened is the town of Charlton had regulated marijuana through zoning, similar to Kingston. And a resident from that particular town filed 2 proposed bylaw changes, one which was a zoning bylaw and one which was a general bylaw. The zoning bylaw failed and the general bylaw passed. The general bylaw was to prohibit marijuana entirely in the town, marijuana uses, not personal. Remember, we're always talking about not personal consumption. And the land court said, no, wait a second. In this situation, the town previously, their history of regulating marijuana uses was via zoning. And because the town opted to take that path via zoning, any prohibition to be effective would have to be through a zoning bylaw amendment. A general bylaw amendment can't invalidate a zoning bylaw. And they cited those same cases which the AG had cited in the East Bridgewater decision. So we're now left with that. The next thing that just recently happened, and I want to say it was in April, was the town of Brewster followed the same path, and a general bylaw was passed which prohibited marijuana. And again, there had been a history in Brewster, however short that history may have been, but a history of regulating marijuana uses through zoning. And the AG, in fact, disapproved the bylaw. So at the end of town meeting, after everyone goes home and the votes have been taken, what happens is the town clerk submits the bylaws to the AG's office for review and approval. And in this instance, the AG disapproved the bylaw and said, you can't have that. So that's the situation we're in, and we're in this situation as of sometime in April, as we head into our town meeting. And so looking at the warrant, and some of you may, oops, sorry. That's to remind me to pick up my son from soccer. Someone else is getting him though, don't worry. We have several articles on the town meeting warrant for this town meeting. And I'm just going to go through them in order, and if some of you have your booklets in front of you, you can refer to them. They're beginning at Article 40, excuse me. So Article 40 and 41 were petitioned articles. And what happens for town meeting, and maybe I'm being too basic here, so stop me if you want to, but any resident of the town can draft their own article for town meeting and present it to town meeting, and you have to get a certain number of signatures and all of those procedural elements to get on the warrant. So these articles were petitioned, and I don't think the petitioner is here tonight. Oh, he's here. There he is. Hello. So this gentleman petitioned the town. The first article is a zoning bylaw article, and what it asks the town to do is to essentially repeal the existing underlying zoning in the town relative to marijuana uses. The second article, Article 41, is a general bylaw amendment to prohibit marijuana uses within the town's borders in all districts. So, left with the Valley Grow, and I'm going to speak for your intent, because I think I understand your intent, and correct me if I'm wrong, but I think the intent of this article is obviously to do a prohibition of marijuana uses in the town to accomplish that purpose. So what would happen if both articles pass? If the zoning article successfully passes and you need a 2/3 majority, and there was a public hearing, a planning board hearing on that zoning article, right? So it's properly before town meeting. But if that passes with a 2/3 majority at town meeting, what happens is the zoning bylaw for marijuana uses will be repealed. Okay. let's not go to step 2 yet. And that means that if we left that night and didn't move one other article forward, it would mean that marijuana uses are allowed in the town but not regulated. So it doesn't mean that you can have a marijuana retailer in the residential zone, or I forget exactly the names of your zones, but in a residential zone or whatever. Marijuana retailers would be allowed where other retailers are allowed. So like your toy stores or your convenience stores. Marijuana cultivators and product manufacturers, depending upon the nature of their exact business, would likely be allowed in the industrial areas of the town. Going to step 2, which is to prohibit, if the first one passes with 2/3, likely folks would want the second one to pass because they're trying to accomplish the same same purpose as the petitioner. So what that would mean is we would take the vote, it would pass at town meeting, we'd submit it to the AG, and the AG, in all likelihood, I can't reach into the future and see what she would say, but in all likelihood would disapprove it on the same grounds that she disapproved the Brewster article. And so there would not be a prohibition. So those are the 2 petitioned articles. Moving on to the next articles, we have 42, which is a town-sponsored article. And essentially what this does is try to, yep, come on up. Yeah, please.
So,
Can you give your name and address?
Mayflower Street.
And you're the petitioner for the
Yes.
folks at home. He's the one who raised his hand. He's the petitioner.
Dave, just
Right.
test it, see if everybody can hear you.
Sure.
back there.
Can everyone hear me okay?
Thank you, Dave.
Okay. So I don't know, my reading of Valley Green Grow, I read the case, was that when there was a conflict between the existing zoning and the general bylaw, then obviously the zoning bylaw would take precedence. But if Article 40 deleted the zoning in its entirety, there was no zoning for marijuana, then wouldn't a general bylaw be sufficient at that point to have a ban in place?
So if you look at, people start waving if you can't hear me. I'm shouting, so I'm sorry if it's picking up strangely on the mic. But if you look at what's called the dicta of the case, what the judge says, Judge Foster says, is that once you have a history of zoning, you can't regulate the use in a contradictory way from the underlying zoning, right? So it's essentially once you've walked that path, you cannot unwalk that path. Once you've chosen zoning, you have to stick with zoning. So the court acknowledges that 94G doesn't specify whether or not it has to be a general or a zoning bylaw. And in fact, when the AG originally came out with her decision in East Bridgewater, we actually spoke against that interpretation by saying, hey, listen, actually, if you look at other statutes, you have to specifically call out a zoning bylaw, and anything else that's called a bylaw really means a general bylaw or all-encompassing. It could be any variety. And so we took that to mean that 94G meant that you could prohibit with a general, and the court confirmed that. But once you walk down the zoning path, you have to, and more importantly, Valley Grove has been interpreted by the AG's office to preclude that possibility. I understand what you're saying, you no longer have a conflict, it's as if it didn't exist, but they look at the history rather than what's existing on the books. Obviously, if it was existing on the books, you'd have even a more clearer conflict. But once you've established that history, that's what courts look to determine how the town is choosing to regulate. Now, let me put in a caveat here, too. Prior to the AG's decision, we could have taken the position, because Valley Green Grow, and we're getting into all technical stuff, but Valley Green Grow is just a summary judgment decision. So they've decided the merits of this legal issue, right? And there's still other things to be decided by the court to finally resolve that case in its entirety. And then there could be an appeal. And there could be criticisms of that case. I'm not contending that this is a binding decision, but the AG has treated this as a binding decision, so we feel confident that she would treat our bylaw in the same way and likely reject it.
Sure.
You know, I can't read the tea leaves, but that's our analysis.
Okay.
So I don't know if that answered your question. It was too much.
No, I understand. I'm following.
Okay.
So so the problem then becomes that because the zoning bylaw just deletes the language and then it moves forward with the prohibition as a general bylaw, that's the problem?
Yeah.
But if that zoning bylaw was an actual specific prohibition on marijuana establishments in Kingston, then moving forward,
Yeah,
that
so,
would be an effective
yes,
ban.
to be super clear, I'm not saying the town of Kingston,
Sure.
oh, yeah.
Okay. Okay, sorry. So my question was, the problem is that as a zoning bylaw, what I had written on there was just deleted all the zoning for marijuana establishments. And at the time, I thought that would have sufficed as a ban. But what I just said just now is if that zoning bylaw was actually a specified prohibition on marijuana establishments in Kingston, then that would not create the controversy or the problem. If that zoning bylaw specifically said no marijuana establishments in Kingston, then that wouldn't be a problem moving forward.
Yeah, to be clear, so for everyone's understanding, that it's because Kingston walked the path of regulating marijuana through zoning, doesn't mean that there can never be a prohibition in Kingston. Should the town or someone wish to propose a zoning bylaw amendment which prohibits the uses, that would certainly be binding. The difficulty with that is whether or not there are folks in the wings and then their grandfathering rights and all of that, those things that are, other consequences. But yes, a zoning bylaw to prohibit the marijuana uses, which would be properly before town meeting if it were heard at a public meeting by the planning board, a public hearing rather, by the planning board, predicated by publication in the newspaper and all of that, and it would require a 2/3 vote of town meeting.
Okay.
Yep.
Is that something that could be brought forward as an amendment on the floor at town meeting then?
So I'm not the moderator, and all questions of scope
Yep.
are determined by the moderator.
Okay.
And so I wouldn't opine to this body on scope.
Okay, I'll talk to Janet about that, but I mean, obviously that was the intent of the, this article, that I wrote and that everybody signed and, the petition of it.
Yep.
Was to accomplish that, not to, create some sort of controversy or,
I will say, generally speaking, scope on issues relative to, I'll get to, if you want to come up behind him and stand up so we don't have to wait, but scope issues generally, town meeting, for town meeting, the decisions of the moderator are very rarely overturned unless there's bad faith, right? So the moderator, the courts very, very rarely overturn a decision of the moderator. So that could relate to scope, it could relate to procedural issues or what have you. The difficulty with zoning bylaw amendments is the courts don't necessarily just look at scope as determined by the moderator at town meeting, but scope as to what was advertised by the planning board as well as what was discussed and proposed at the public hearing. So that's another complication with the zoning bylaw, and to suggest that a motion to repeal a zoning bylaw was within the scope to mean a prohibition is, I'll say, difficult.
I think we did talk about that at planning board, Rob. I don't know if you remember that specifically, but I think that there were some rumblings, about, what I had written as the zoning bylaw possibly creating issues. And I think we did actually specifically speak about that at the public hearing.
Yep,
About
and I'll
intent
repeat
scope.
that for the folks in the back. What he said was there was actually a discussion about a prohibition at the planning board hearing. That said, advertisement is the key. So like at town meeting, the warrant, if you're determining scope, this is going to sound silly, but the rule that you use is if I'm sitting on my couch at home reading the warrant, are the contents of the written warrant something that would encourage me to come to town meeting? And that same kind of rule of thumb applies to the planning board advertisement. So if I'm sitting deciding whether or not I want to get out of my couch and go to the planning board hearing to see Rob on a particular subject, is it encompassed in that advertisement in a way that would let me know that that would be discussed? Whether or not it was discussed is not as relevant, so.
Sure.
I just had a quick question on clarification regarding...
Can you say your name and address?
Yes, Paul Sardella, 73 Ring Road. I just had a question on clarification. I thought I had read some language somewhere regarding making zoning changes specifically targeting the marijuana industry, that would not be allowed in Massachusetts law. Did I read that wrong?
And I'm going to repeat for everyone in the back, your question, and so I understand it.
Yeah.
Your question is, could there be a zoning bylaw amendment
That's
to?
not allowed due to it specifically targeting marijuana or marijuana establishment.
I see what you're saying.
Yeah.
So the question is could you have a marijuana bylaw which directly addresses marijuana uses specifically as opposed to, I don't know, like some industrial use, like say more generally? And the answer to that is no. And I'll tell you what I think you might be thinking about, or maybe, I don't know.
Yeah.
But so one of the things that we think about in zoning is whether or not there are constitutional issues. So this comes up in the adult industry, not adult entertainment. Thank you. Adult entertainment context a lot, because in those situations, and there's a ton of case law where towns, when they were forced to allow adult entertainment uses in the towns, they stuck them in the most remote area, in the smallest part of the industrial zone, on top of an overlay. I mean, so it was essentially impossible to cite an adult entertainment use. But the difference is, for adult entertainment, they have constitutional protections because that's considered First Amendment, whether or not a person wants to display their body or see someone display their body is First Amendment protected, whereas marijuana uses aren't. So the answer to your question is you could specifically zone against marijuana uses, for sure.
Okay, good to know. Thank you.
My name's Janet Stanford. Can everyone hear me?
If I can repeat her question too, if she
Well, I'd
asks
rather
it.
be heard.
Okay, then, yeah.
Is there something wrong with this mic?
They capture for the camera, that's
Oh.
why I'm shouting. They capture for the
Oh, okay. So
camera,
should I
but-
just turn a little bit?
Sure,
Okay, so my question is about scope. I'd like to get back to that.
yep.
When, last year, the last time we voted on this, we were talking about, a resident got up and talked about, a resident got up and was first talking about reducing the fines, so he was talking about the general bylaw. And then I don't remember the exact wording, but he said basically, and remove 4.2, which was the actual ban or the moratorium, however you want to say that. So my question is, that shouldn't have been allowed within the scope of what was being discussed that night. That article, the moratorium was in that article, and that resident just had it removed. So I'm going to really question whether that should have been allowed during last town meeting. And if that was improper, then why can't, I don't know how to say this, then maybe that vote was just, shouldn't have ever been allowed by the AG to begin with. And can we go back and look at that and say, that was invalid, that decision last year was invalid?
So again, number one, did everyone hear what she said, even though she was projecting? So the
sorry.
question was, last year, was it last year?
Last year.
Last year, there was an amendment on the floor which eliminated the moratorium from the article as moved, and whether or not that was in the scope. And so my recollection, to be fair, is there were a bunch of amendments made to the public consumption article. Am I mixing up town
Right, no,
meetings?
that's-
There was a public
right.
consumption article
The
on
fine,
there.
yep.
And it was about a fine, and
Right.
there was a lot of back and forth of where we should prohibit public consumption of marijuana and in private ways versus public ways
Right.
and all of that. The moratorium, I don't believe was on there, nor should it have been, because a moratorium is a zoning article, so it wouldn't have been under the general bylaw. So I think you might be confusing
No,
terms, but what was eliminated,
was-
Elaine? There you go.
He's the
Here
one,
he is.
Mr. Randall,
Dennis,
He
you
made
have
the
to
motion.
take the microphone if you would.
May I speak?
Can you take the microphone?
Dennis Randall, 39 Winter Street, Kingston. The motion was, there was an article before town meeting which established a penalty schedule for the public consumption of
Yep.
cannabis.
Yep.
And what I did was, and it had a bunch of other draconian measures there that, virtually a SWAT team comes out and delivers the ticket and all that. I simply had taken the language for the prohibits the consumption of alcohol
Yeah.
and substituted the appropriate general laws and stuff like that, and made the fine for the public consumption of cannabis exactly the same as for the public consumption of alcohol,
Right.
both of which are prohibited by our general bylaw.
Yep.
One is kind of a $25 fine is what it is for the public consumption of alcohol, plus the police officer has to be in court. What that really practically results in is, more often than not, if the cop sees you drinking or something like that, you should be drinking, and say, yeah, dump the can, get out of here, don't give me any problems.
Yep.
Nothing happens. It's not worth the cop's time to take you to court for $25, nor is it worth your time to hassle. The same kind of thing. The intent of the motion was to not create a double standard within the town. That is all. And it was very clear and straightforward. The moderator advised, because I made it clear that the intent was to completely strike and replace
Right. You were
the
jogging my
language
memory.
before. The moderator said the effect of Mr. Randall's amendment will be to do this, which will eliminate all prohibitions against marijuana. That was repeated several times. You can watch the videotape, and it passed overwhelmingly.
Yeah, you're jogging my memory. So what happened in that circumstance was the public consumption bylaw was replaced with a bylaw which more mirrored, I'm repeating it so those guys can hear, more mirrored what the public consumption of alcohol was like. And that makes a whole lot more sense to me, and you've jogged my memory, because the moratorium is a zoning article. It would never be in a general bylaw. But and two things. I want to address your second question before, and I'll let you come back, I promise. In terms of scope, you say, should we ask the AG if she reviews scope? The AG doesn't review scope of that nature. It's the moderator's discretion to determine what's in the scope, and the moderator has very, very broad discretion. And as I said, I'm not going to comment for the moderator as to what she'll allow for particular amendments on these articles. I did say that a zoning article, which, or a zoning bylaw, excuse me, which could be appealed, they wouldn't necessarily look at whether or not the moderator improperly allowed an amendment that was outside of the scope, but they would look to the planning board advertisement to determine if that was within the scope or not. So that's the tricky part with zoning bylaws. And that's one of the reasons why the court came down with the decision it came down with, because the policy behind ensuring that zoning bylaws aren't overridden by a general bylaw is all of those procedural protections which are required prior to enacting new legislation on zoning. So you have to have the notice in the newspaper for 2 successive weeks, so that folks know to come to the planning board hearing. The planning board has to have a public hearing, which allows public comment, so they can make sure that what they're proposing is, well thought out. The planning board issues a report, or a certain amount of time elapses before town meeting, with their recommendations to support or not to support, or however they're doing it. And then you need the 2/3 majority vote at town meeting. So that's why courts are reluctant to say that a general bylaw could supersede a zoning bylaw. I don't know if that answers your question,
Can
but
I
go
ask
ahead.
one, just a follow-up question?
Yep.
So, then as Mr. Randall's amendment, if that wasn't discussed at a planning board meeting in a hearing that we're gonna make this like alcohol, wouldn't that be a problem right there?
So I want to be super clear. Mr. Randall's amendment was to a general bylaw on public consumption. It had nothing to do with zoning or allowing marijuana uses in the town. So had the town, for example, completely prohibited marijuana from the outset, you still would be dealing with a public consumption bylaw, because under 94G, it's legal to consume marijuana. So a person can sit at their home, and I'm not pointing to Tom. I'm gonna keep my hands down. A person can sit at home or in their backyard and consume marijuana, no problem, regardless of whether or not marijuana uses, the commercial industry is allowed in the town. And what Mr. Randall's amendment related to was public consumption. So just like I could have a beer at my house, I'm not allowed to have a beer on Evergreen Street and on the sidewalk and walk down the street. It's not allowed. I can't do the same thing with marijuana. And so that's what Mr. Randall's amendment was.
Well, I'll step back, but I'm still confused because his amendment also got rid of the moratorium, so you keep on talking about public consumption.
No, so it really didn't get rid of the moratorium. Mr.
But he just
Randall's-
admitted that
No,
the
he didn't
moderator said
admit
over
that.
and over again that if this goes through, then there won't be a ban anymore. So he just said that.
As a clarification, my understanding, and I'm not town moderator, but I did serve as the first parish moderator for 30 years. Within the scope of an article and an amendment, you can weaken an article. You can amend it down.
Yep.
You cannot amend it up. The fine established for public consumption of marijuana within the article that I amended was $400. I amended it down to 25 and replaced all the other language, which resulted in essentially a police record. We didn't want that for our kids. And the town agreed. So, and as far as the moratorium goes, the moratorium was expiring anyhow. That was not before the assembly. An outright ban vis-a-vis zoning was. And as it happened, and is likely to happen even at this town meeting, unless there's a compelling reason otherwise, is zoning is much more difficult to overturn or to pass. It requires a 2/3 supermajority. And one of the reasons, as your explanation, is the way the courts, I understand, not a lawyer, rule is a 2/3 vote accomplishing item A has more gravity and weight than a majority vote accomplishing the exact same item. And you cannot use a simple majority to essentially kill a supermajority vote. It has to be on a same footing, the same ground.
That's correct. And I just want to go back to the moratorium. The moratorium is a zoning bylaw. It wasn't connected with this public consumption general bylaw. And I recall, and it was when we were switching planners, I was asked initially to extend the moratorium because the town had voted originally in 2016 to not legalize marijuana. So we could do anything we wanted by bylaw. We weren't triggered by, some other towns had to trigger a ballot. And And that moratorium failed. They didn't garner the 2/3 majority. And I think, Jess, I think you spoke on that and you said we should pass the moratorium is only a temporary measure, and it allows the town to decide what to do in terms of marijuana uses. Am I remembering correctly? Yeah, zoning should be in place first. If we're going to allow marijuana, zoning should be in place first. So let's be mindful of that when we're voting on this moratorium extension. And it just didn't garner the support. There's no way to amend a moratorium, because all a moratorium says is either we're going to take a pause and get our ducks in a row or not. I mean, it's not something like the public consumption was, what do we want our fine structure to look like? Where do we want to prohibit it? There's a lot of moving parts there that you could tweak. The moratorium wasn't amended. Go ahead.
Sure. I don't know if I'm reading this incorrectly, but I actually pulled up the minutes from town meeting for last year, and
Yeah.
I mean, it looked like, I mean, it's kind of complicated for the section, a lot of amendments, like you said, but it looks like the motion to amend, you know, removed all these sections, 671, 672, 34, you know, which was a 671, public consumption forbidden, recreational marijuana establishments prohibited, enforcement penalties. Those all got removed.
Oh, okay.
And then
So
what was put
it was
in-
a general bylaw prohibition. Can I see it?
Sure.
Yep. Can I turn it? Oh, it doesn't flip. Okay. Move. Oh, this is awful. I can't read it at all. Okay, hold on. Public consumption forbidden. Oh, recreational marijuana. Okay, so this is great. Okay, so that makes sense then, because it's not a moratorium though. That's not the right word. Yep. So that can happen, and whether or not that's within the scope is not before us, but that can happen. There can be motions to amend, and I think this is a really I'm sorry, thank you. That article was a general bylaw prohibition. It was not a moratorium, which would be a zoning article. And again, as Mr. Randall aptly articulated, it is within the scope, generally speaking. Don't want to say every single circumstance, to make it less restrictive, less harsh. I mean, when you talk budgets, it's different, but generally speaking, that's a good rule of thumb to go by. Because if I'm interested, play it out a different way. If I'm interested I'm completely opposed to a prohibition, so I'm going to get myself to town meeting, because forget about if I make a motion to amend, I can vote against it. It would accomplish the same thing as that motion to amend did, which struck that provision. But folks, including Mr. Randall, said, well, I'm not on board with the prohibition, but I'm on board with public consumption prohibition to a certain degree, but not how Kate Federoff wrote it. But I can work from there, because if I'm sitting at home, I'm going to say, I am absolutely in favor of this prohibition, and I'm going to make my vote heard at town meeting to prohibit. Just because an article gets on the warrant doesn't mean it's going to pass. So in my mind, that if I were a moderator, I would say that's absolutely within the scope, because the same thing could be accomplished by just voting it down. But they opted to say, we like parts of it, just not all of it. I don't know if that's helpful. Does that make sense to you? What's her name? Janet? Okay. Does anyone else have any other questions on 40 or 41 articles?
Chris Luongo, 19 Ring Road. I'm playing catch up. I wasn't at the meeting last year. So to clarify, because I'm a little confused and I was getting shushed for asking, Mr. Randall's motion at that last meeting, because that passed, is that the reason we're allowing the shops in Kingston, essentially?
No, so just to be clear, a zoning bylaw, which regulated the uses of marijuana, it said, the town of Kingston is gonna allow marijuana retailers in one area and marijuana cultivators in another area, and we're gonna put a special permit on. That article passed by 2/3 majority vote.
And that was, unfortunately, I wasn't around for that when
Sure.
that was going on. All that was published, and everybody knew going to the meeting that was what they were gonna be voting on?
Yes,
Okay.
that article was certainly published.
Okay, and then,
Fall town meeting.
okay, so,
Right, because that's exactly, June.
When it didn't pass in May.
That's
We
exactly
immediately
right.
had another town meeting special.
Yes.
Because we had no
Be-
regulation.
Because the prohibition failed with Mr. Randall's motion to amend, so the
so that's,
prohibition failed.
that's ultimately my question.
Yeah, and so we hurried up.
Because that motion
Yeah.
failed,
Yep,
that's the reason we're here.
I guess so, yeah, to some
So,
degree, and we're here because there are petitioned articles, yeah.
So, my question now goes back to the original question about scope. Would that fall, I mean, sitting on my couch reading that, I would have shown up.
Well, it was published, so I don't know why you wouldn't have read. There
Okay.
was a June town meeting after the prohibition failed. We got a planning board meeting together, we drafted a zoning bylaw, we had the hearing, and then we had a town meeting in June to address this very issue, because what we didn't want to have happen was to have marijuana uses be allowed in the town of Kingston, but wholly unregulated, right? Because if you don't have zoning ordinance in place, or a moratorium in place, or a prohibition in place, you're left with the default, which means marijuana is allowed because they didn't prohibit it, and then you can't pick which parts of town you want to allow the marijuana uses in. But I can guarantee you that that town meeting warrant was published and posted, and it had the exact language of the zoning bylaw in it. And I don't know why you didn't see it, sir. I'm sorry.
Chris, could I interrupt for one second? Yes. My name is Susan Sherman, and I've been quite upset because our moderator's not here. Oh, I've been quite upset because our moderator isn't here, and she, in fact, as you have said, all your information is wonderful, but she, in fact, has a lot of authority on this. I just called, and she was told the meeting was at 7. So she is on her way here. Could we take a quick break and wait for 10 minutes? I believe she was in Hanson.
Okay, or we can just
How does
move
that
on
sound,
and
people?
come back to this. I don't care. Is that okay?
Do you mind if we'll go on to the other articles that are unrelated?
Excuse
and
me
then
for one
come
sec.
back to
I
40 and 41?
understand that you want to continue on, but if you just respect our feelings.
Of course.
I don't appreciate you saying you don't care. I know how you meant it. I'm just taking it a different way.
Oh, I don't care. I
know.
don't mind waiting.
I understand, but the way I interpreted it was that you don't care and you want to continue.
No, she doesn't
So
mind waiting.
just,
I don't mind waiting.
We're having this to get everybody
I-
educated and informed before Saturday. We're all willing to listen.
I don't mind waiting, but if you'd like, because I think most of you are here for Articles 40 and 41, or maybe I'm misreading the room, but we can move on to the other articles and discuss them while we're waiting for the moderator. Does that make sense?
Yes.
All right, so the next article, which is Article 42, is a zoning bylaw, which was put forward by the town. And essentially what this tries to accomplish is to allow marijuana uses in more locations, to allow for more opportunities to cite marijuana. It makes clear the buffer, because originally when the zoning bylaw was drafted, one of the buffer requirements was, and it was pulled from the medical marijuana legislation, and it's where children commonly congregate. But that's what we call, to some degree, squishy. There is some guidance as to what places where children commonly congregate include. There's some guidance on that, but it's not black and white to the reader. There is some subjective elements to determine whether or not it's a place where children commonly congregate. So, for example, the DPH, which used to regulate medical marijuana, has issued an advisory, and what they've said it means is not an ice cream shop, because everyone goes to an ice cream shop, and yes, there may be plenty of children at an ice cream shop, but it's not targeted, a use that's targeted to children alone. They said, but for example, a children's playground would be a place where children commonly congregate. So what the town's goal in modifying that was to just make it very clear and simple, so it's black and white. It doesn't require someone to analyze the amount of children at a certain place or whatever. And it's further expanding the areas to include the commercial / industrial park district, which, Rob, I don't know if you can explain where that is.
That's right next to the industrial district.
It's right, I can't hear you.
It's right next to the industrial district.
Oh, it's right next to the industrial district. So, and basically all the rest of the zoning, which had been previously approved by town meeting, remains the same. The next article is Article 7, marijuana retailers. And, oh, I know what this is. I'm sorry. Marijuana retail. Do you want to speak before I go on to the next one?
The previous article.
Pardon?
The previous article.
Oh, on
about,
40, the zoning?
42, I believe.
Yeah.
I'm not sure at what point that it changed, but I know when I was going to the meetings and the planning board meeting, I spoke with Rob about it the other day. I was told in the meeting, and I think in the public hearing, that this was an article that was going to have separate motions, because, so you could vote, yes or no, expand into the industrial zone for retail, yes or no, drop the buffer from 1,000 to 500 in certain areas. And then now looking at it, it looks like it's kind of an all or nothing deal. I'm not sure what changed. I don't know if I missed something between that meeting and the printing, but.
So I wasn't at the planning board hearing, but as a procedural mechanism, so for example, if you feel, and I don't want to tell you how to play your cards, but if you feel like one piece of this bylaw amendment might be really useful to you and it would be something you would like to see pass, versus one piece you're wholly against, but you don't want to see the whole thing go down in flames, you can make an amendment on the floor to say, I want to amend to strike the addition, and this is off the top of my head, I'd have to think about it, but strike the additions relative to buffer, but while maintaining all the additions relative to the change in districts, or something like that. Or you could ask the moderator to somehow divide the question, which might be a little more complicated.
I'm not sure what happened.
I can't tell you.
Rob, were you able to get any clarification on that? Okay.
I don't know.
I mean, it was,
What you're talking about before the planning board?
yeah, at a planning board meeting, I got up and I asked that question because there was some pieces of that I agreed with and others that I, didn't quite agree with.
Yeah.
And I asked and I was told that there were separate motions, that you could vote separately on separate pieces of that. And, now it looks like it's just all or nothing. So I'm not sure what happened between there and here.
No, this is our article, 42. And I can't tell you, I wasn't at the planning board hearings. I don't know. I really don't.
Okay. Did anybody else remember that? I don't know, Rob, do you remember that meeting or?
Originally intended to be separate motions.
Okay.
It's now printed in the
Okay.
So we can get clarity from the planning board for you, and the only way I believe that can be dealt with is on the floor now, is that correct?
Yeah, I mean, we can't, the warrant's been published, so we can't change the warrant as posted, but you'd have to do your,
On the floor.
Okay,
your
but
motions on
wouldn't
the
it-
floor.
Wouldn't it be, wouldn't people just, shouldn't we be able to just assume that what we discussed in the meetings and the public hearings is what's gonna happen on the warrant? I mean, that's kind of the process of going through this whole, rigmarole to get from,
Yeah.
working copy to, finalized, voted on, I don't know, legislation or what to call it, at the town meeting floor. I don't understand.
So I honestly just, I can't speak to it. I wasn't there,
We will speak with them. We'll get some clarity
Okay.
and ask for the planning board to weigh in when you make that
Okay.
floor amendment.
Sure, okay, thank you.
Elaine, please. Go ahead,
Still
sir.
on Article 42, please.
Go ahead.
Unfortunately, yeah.
Donald Hill, 60 Elm Street. So on Article 42, there's a lot of things that are crossed out about other locations where minors congregate. So if a citizen wants to approach town meeting and ask for an amendment to that to include town parks, is that an acceptable, or is, because this is printed the way it is, that's it? In other words, it says playgrounds and things, but it does not include town parks.
So that's a good question, and again, it's a scope issue, but I don't even have to address whether or not that's in the scope, because if you look, I think, hang on. Oh, here. If you look at Article 43, which is a petitioned article, there, and I don't know if the petitioner for that article is here. Is it? Oh, there he is, that gentleman right there. He's adding public parks to the buffer. So you don't even have to.
Question answered. Thank you.
Thank you. Elaine Fury? And then Craig?
I was just going to say, if, Rob, the intent was to have separate motions, if we confirm that between now and town meeting, we can do the written up, do an amendment to present at town meeting in writing with the separate motions.
Yeah, you can do that.
So we can work on that to make sure that it's the separate motions, if in fact that was the intent.
Sure.
Rather than having it presented at town meeting and not be vetted, I guess you'd say.
Yeah, that's a good point,
Good idea.
Elaine, thank you. Yeah,
As to what we were just talking about there, for a procedural matter then, if Article 43 follows this, and I guess this changes the whole article that Article 43 was going to amend. So the sections that we're amending
yeah.
in Article 43 aren't there anymore.
And your name is Craig?
Yes.
Craig.
I'm sorry, Craig Dalton, 11 Elm Street.
That's fine. And you know what? As a matter of sheer fact, I, just because I knew this was going to be an issue, right? Because it's hard to navigate this stuff on town meeting floor, to be honest. So is this
Got that right.
Your memo?
my summary?
I believe it is.
No.
It's not summary? It's not online? So it's
No.
not yet?
Is it going to be?
Sure.
Yeah, okay, so I actually did a summary on this. I might add the AG's opinion, but I did a summary on this, and so let me be clear. I won't guarantee to do this because Town Council does not look at the petitioned articles, because what happens with petition articles is they come in as they are and they get published, warts and all. Yours didn't have warts, I'm not suggesting that, but, they come in as is. We can't modify them to make them work within our bylaws. We can't do anything.
We're
They
not
just,
authorized to do so.
we're not, right, it's prohibited. So we don't look at them, we don't give you advice because you as a petitioner, you're a resident of the town, but I work for the town, not the individual residents. But because it was so super confusing, I did do a summary, and I suggested, well, if 40 passes, then you're also out of luck. But if 40 passes, this is what can happen with 41 and all of that kind of jazz. And for your article, which one's yours? 43?
43, I believe.
43, I actually even suggested a motion because yours can be accomplished, and it's definitely within the scope, because yours had the specific subsections and lines. So what I said was something like, I move that this, when you move your article, instead of saying I move as printed in the warrant, you could say something like, I move that subsection Q of section 4.214, locations, blah, 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 be amended by inserting public parks after the word public libraries in the first and second sentences. And that's if the town's Article 42 passes, so you don't have the semicolons and all of that stuff that exists in the current bylaw. So I don't know if it's helpful to you to have that.
So it would be like the gentleman was suggesting before, though. It's basically amending Article 42. It's not really an amendment that way, but
Yeah, well,
wouldn't it be
you're.
simpler to do that? Amend Article 42?
Well,
or
okay,
something
but
that you
talk
include?
procedurally, so if 42 is ours? If 42 comes and we have all these motions, in order for you to amend it, you have to first make a motion to amend, which then has to get the requisite number of town meeting votes, and then you have to then vote the amended motion, so it gets more complicated. Since you already have an article, I don't see why you'd bother amending 42. And it's all personal preference, though, to be honest.
Okay,
You know,
well,
I
then-
don't see why you'd go with 42 when you already have printed in the warrant 43.
So you have something in there about that?
Yeah.
Why, how to do that?
Yeah.
Okay, then.
And normally I wouldn't do that, but marijuana is hard, and there's a lot of moving parts, so.
All right, so,
Yeah, I can give you a
Craig, we'll give
copy.
you a copy of what Kate wrote up on Article 40.
okay, thanks, yeah. Procedurally, though, this article here, the 42, 4214, Section Q,
Yep.
this is basically this area of change. It's saying that a retailer may be located within 500 feet if it's in an industrial and commercial industrial park. That's the change, big change there, right? So if the retailer, the proposed retail location's in a commercial industrial park, then it can be within 500 feet of anything that's listed down there, is that right? Whereas if it's in a
Yes.
commercially zoned area, has to be 1,000 feet away.
If it's for commercially zoned, it's 1,000 feet, 500 feet from the industrial and commercial / industrial, which is different. So,
Right, but it's located in those. That's what determines it, its location, right?
right, so,
okay.
yeah, so a building within that zone, the, say, commercial / industrial zone, that has the 1,000-foot buffer. But if you move down the street to the commercial zone, you're with a 500-foot buffer, yeah.
Or the other way around.
The other way around, yes.
Have Janet come up here.
But it's the actual location of the physical property, yeah.
Excuse me.
Okay.
Janet, would you mind coming up front?
Oh, no, I was told to start at 7, so where I'm an hour late, I prefer to sit back here. Because I am not from Providence at all, so.
Okay?
Couple other procedural things. If 41 and 42 pass, and for whatever reason, they pass, well, I guess that wouldn't work, would it? Then it doesn't really matter with 42. 42 would amend, it would just create a new thing, right? If 40 and 41 pass, does that affect 42 going forward?
If 40 and 41 pass,
Right.
I don't want to step in the shoes of the selectmen, but I would take a hazard to guess that they wouldn't move 42 because 40 and 41 just passed. But maybe they would move it, I don't know, and see if they would get the 2/3 majority. I don't know what the Board of Selectmen would do. Oh, the Planning Board, excuse me. I don't know what they would do.
Okay.
My suggestion for anyone who's interested is stay until the end of the marijuana articles.
Mm-hmm. And just if you could go over the changes for the, in the tables here, in bottom page 32.
Yep.
The changes, if you could just highlight the changes between those principal use tables, just make sure that we know what's been changed in those.
Right, so essentially the use tables are a quick guide for people to locate what's allowed, and because we've extended the areas where marijuana uses may be allowed, so you'll see in that first row for marijuana retailers, instead of being NP, which is not permitted in the industrial zone, it's an SP, so permitted by special permit. And same thing for the CIP, which is the commercial / industrial zone, where it was NP before, not permitted, it now would be SP, which is permitted by special permit.
And the C notes 1, 4, and 5 below that are crossed out, what were those referencing?
Rob, do you remember what the notes were in reference to? I can't remember.
They weren't actually referencing that anything. They were just, they
Oh,
were
was
taken note originally in the bylaw.
It was just a Scrivener's error that we're correcting. Okay, thank you.
All right, thank you.
Are there any other questions on 42? No? Okay. So, 43, we just had a preview of, and again, that's a petitioned article by Craig. And that is to add in the list of buffer areas, so what we call sensitive receptors, where we have schools, K through 12, playgrounds, and what have you. He also wants to include in that list of buffers, public parks. So that would include, what's the big park there?
I was distracted, I'm sorry. Was it-
What's
oh,
the-
Sampson?
That would include Sampson Park in Kingston as being a sensitive receptor. Mr. Randall, did you have something, or no?
Oh, no, I was.
No, you're just going, okay. So that's easy, and again, that's a zoning bylaw, 2/3 majority vote. The next article is Article 44, and, oh, right. Article 44 is creating a buffer from residential areas by 100 feet. So right now, and I don't have a zoning map in front of me, but if you have an area that, you know, a marijuana facility could locate in, it still also has to be 100 foot from a residential zone. And again, it's pretty self-explanatory, I think.
So should we go back to 40 and 41?
And, oh, one last thing, 45, Article 45, which for the folks who are proponents, and if we're going forward down the path of maintaining marijuana uses as a use that's permitted in the town by special permit, this is a tax on marijuana sales, which are sold at a marijuana retailer. Now, to be clear, it doesn't apply to your cultivators and those wholesale exchanges between cultivators, manufacturers, and retailers, but rather the retailers to the customers. So it's a 3% tax that the town could collect. So going back to Articles 44 and 40 and 41, Janet, one of the things that we had discussed at the outset of the meeting was the question was raised, because let me give you a little bit of framework. I know you weren't here, so I'll give you a little bit of framework. Article 40 is a zoning bylaw amendment.
Zoning and the 41 is the general. Yep.
Yeah, okay, good. She's quite familiar. So we talked about Valley Green Grow and the AG's decision and all of that, and how the perhaps unintended consequence could be that the underlying zoning is repealed and the general bylaw is rejected by the AG's office. And one gentleman, and I'm forgetting his name,
David.
David, had asked whether or not he could make, because I discussed how you can prohibit marijuana uses via a zoning bylaw, but because this is a general bylaw, we have unintended consequences. So he had asked, well, can't I just make a motion to amend Article 40, which is the zoning bylaw, to instead say repeal, but repeal and replace with something like the following. Marijuana uses shall be prohibited in all districts within the town of Kingston, something like that, if he were to make that motion. And I said, look, I'm not going to opine whether or not the moderator would say that's within the scope, but the zoning bylaws are reviewed for two purposes. It's whether or not you chose to find it's within the scope or not is within your discretion. And I said it's very rare that moderators are overturned on their decisions relative to scope. But I said, in terms of zoning bylaws, because you have the planning board hearing, and this is where we have a lot of case law, is whether or not it's within the scope of the public hearing advertisement. And I said, without giving an affirmative answer one way or the other, because you can never know for sure with a court what they would do, but I said it would be difficult to say that such a modification would be within the planning board's advertisement, the scope of that advertisement. And I said I wouldn't speak for you. And so as a consequence, the folks here were looking for, and I don't know if you want to opine on that right now, but the folks were looking for you to weigh in. Is that a fair summary? I think so.
Yes.
Just reading it.
Yep,
Reading it.
please, please. I'm okay. I'll have to.
Does anybody do you have the zoning bylaws with you as well?
I do. When you come up.
It's great being with
So.
you. You had a lot more value, Jen.
Oh, no.
Please.
I just want to see what the zoning bylaw is.
Here's the zoning bylaw with the prospective changes, but you'll see there's strikes and underlines.
Okay, but this is not, I mean the current zoning bylaw.
That's the current zoning bylaw, and just the additions are underlined and the strike-throughs are being deleted. But you can see from that what the existing is.
Folks, do you want to take a 5-minute break?
Yeah, if you don't mind,
Yeah.
because this is.
Folks, we're going to take a 5 to 10-minute break as the moderator and Kate discuss this. Thank you.
All right, so I had an opportunity, Janet Wallace, as you know, moderator, hadn't. Yeah. On Article 40, I'm assuming he's getting the decibels on that. On Article 40, so council just told me in regard to the question of whether or not I would allow an amendment on the floor to actually add a prohibition of marijuana. And that's, as my job is always to look within the four corners of an article. And what we've done is repeal it. So technically, and that, you're looking at that and saying, oh, well, isn't a repeal the same as a prohibition? They're not. A repeal means we have no bylaws. A prohibition is adding a bylaw. So I wouldn't rule that within the four corners. So I think it's just going to be whether or not we do or don't repeal it. I think this is yours.
Yeah, just a quick
So thank you very much, by the way.
So,
I was looking at it online, but there you go. I'm assuming you're David?
Yes.
Okay, because we spoke on the phone.
Yes,
Okay,
we did.
yes.
Nice to meet you in person. So when I wrote the article, obviously it was for a prohibition. And in the zoning bylaws, under the use regulations right at the beginning, I don't have it in front of me, so I can't quote it
Yeah.
for certain. But
Oh, under the original, the beginning of the zoning bylaws?
yeah, in the
Okay.
actual use regulations, it says at the very beginning that anything that's not specifically permitted in the zoning bylaws is prohibited,
Yeah.
any use. So I
Yeah.
mean, wouldn't that, and
So,
that,
and I understand what you're saying, and Town of Kingston does have that. So there are two types of zoning bylaws, one which allow everything unless it's prohibited, and one which prohibit unless it's allowed. And zoning in Kingston is the latter. That said, that because it's not like a separate, so it's not like something very distinct in that it's a marijuana retailer is just under the umbrella of retail, for example. Whereas if you have think of something in an industrial zone like a UPS place where they park the trucks is allowed in the industrial zone, but a smelting plant, which isn't in that umbrella, it would not be allowed, okay? So, but you have to look at it a little bit differently in that, so it doesn't list, for example, toy stores, it lists retail. So that's the distinction. It doesn't say toy stores, grocery stores, all other kinds
Right,
of
of
retailers
course.
that you're thinking about. It lists retail.
yeah.
So
but
that's.
Isn't this a
that's-
special case though? I mean, there's like a whole lengthy special permit process. I mean, this is a huge, this is a very, we're not talking something nebulous like just retail. We're
Yeah.
talking, marijuana
Yeah.
establishments. Like there's a very specific
Yeah.
special permitting
I hear,
process.
and there could be an argument that someone might lodge that if it's not listed, it's prohibited, and because it's a particular thing and it was recently legislated, yeah.
So
it-
when
it
we
could
wrote the
be-
beginning, it wasn't legislated at the time, now it's
Yeah.
legislated, so it
It
couldn't
could
have been
be
true.
that argument is lodged, but I'm telling you that I think that would be an uphill battle. I'm not telling you what battles I would fight. What happens at town meeting, we're left with, and we decide what battles we're going to fight in court, So I'm not telling you, I'm just trying to give you the best advice of what I think would withstand judicial scrutiny.
Sure.
And because it falls under the umbrella, it wouldn't be, because you mentioned, for example, the special permit, and this is unique, well, but we don't have that anymore because it's been deleted. So,
Sure.
and that's the one thing, special permits are great because they allow you to control a particular use based on the actual placement as opposed to like just putting a blanket over the commercial zone and treating it all the same. You can say, no, because it's in the commercial zone, but it happens to be near the, I don't know, something that is sensitive to you, I'm gonna condition around it, or there's not enough parking, or whatever, and you can condition around it.
Sure.
But that special permit stuff will be gone
Right.
if your zoning is passed. And again, I can only emphasize that Valley Green Grow is just a land court decision, and we don't have any confirmation of what the appeals court will do should they appeal. There are arguments that I could certainly make that conflict with the decision's outcome, but I'm just Kate Federoff, and no one cares about that. So I can only give you advice based on the state of the law as it is in this blink of an eye. And that's where we are with this land court summary judgment case.
Sure.
Because the difference is that they voted the zoning bylaw with only a majority vote, not a
Right.
two-third vote.
Yeah, they didn't get
And
the
that was
two-thirds.
that's a secondary issue under that case.
Okay.
You know what I mean? Whereas yours is looking at a two-third vote.
Yes.
Right. So, I mean, I think one of, David, so we had talked before, there was
Yeah.
a change in the flip in the two articles.
Sure.
From that the general bylaw would have gone first. And I understand your position then was you wouldn't have moved your zoning bylaw if the general bylaw wasn't a prohibition.
Right, and the combination of the two, I mean, certainly the intent was to, create a prohibition, so.
Correct.
I'm not sure, I don't know if it's just me that's not understanding it, but I just don't see how, I don't know if I'm just not following your reasoning of not allowing an amendment on that to, create the prohibition, which is the absolute intent of the article, and the petitioner is, that signed that.
And what I'll do, just to be honest with you, obviously it just came up, it's just sudden.
Yeah,
I'm
absolutely.
reading it, my first gut reaction is no, because the issue was to repeal and have no zoning bylaw as opposed to have a zoning bylaw that's a prohibition, and those are two different items. What I want to do is read a little bit more up, even in town
Okay.
meeting time, about the difference between the two, because I mean, clearly, the intents are the same. The
Right.
intents are exactly the same.
Right.
You want no zoning bylaw, but really, you really want a prohibition bylaw.
Exactly.
You know, under the zoning bylaw. So, so I get what you're doing. I'll definitely read up on it more and talk to you before town meeting as well. Because obviously the issue becomes is if the zoning passes and the general doesn't.
Right.
And I think what Janet's probably going to look at too, and I would say this, is your intent is super clear to everyone in this room that
Sure.
you wanted to prohibit marijuana, right? You petitioned both articles.
But the notice to the citizens
But
is different.
whether or not the citizens understand that intent is the critical question.
I
Yeah.
think that's pretty clear. I think the citizens absolutely understand the intent, and
Yep.
in all the meetings, and I mean, again, back to the planning board meeting where I was, talking about that, there was specifically a back and forth between me and Tom Bouchard, about that, and the intent was absolutely clear to him. Anybody that was watching that planning board meeting totally understands. So, I mean, I don't
Is he PACTV?
understand.
Is
Sorry.
the planning board meeting still up? Do you know? Okay.
So I don't know why
Because maybe
that
I'll
would-
watch the planning board meetings.
Sure. I don't
You know
know
what I
how
mean?
far
And
back
just
they
do
go,
that
but
as well.
I do.
They do take them down after a period of time. I just don't know.
Sure.
Okay.
And
thanks, Gloria.
again, if Articles 40 and 41 pass, as I said before, I'm not looking into the crystal ball. I am
Sure.
not the Attorney General, and I don't know exactly what she will do. We'll see, So it is what it is. I just tried to
Right.
give you the most information you could have, so you'd be well-equipped to make an informed vote.
Well, sure. And I mean, I think that all the citizens that are going to show up on Tuesday night to, hear all these articles, they're going to show up there because there's a ban. They're going to show up to either vote for or against the ban. So I think that pretty much, that argument of, what the person will get up off the couch to go and vote about. I mean, that's it right there. The people are coming to vote for or against this, regardless of whether it's a deletion of language or a specified prohibition of a ban. So, I mean, when that,
Yeah, I mean,
fulfill
people are also
that.
coming for the 1,500-foot differences in the buffers and the,
Sure.
100 foot from a residential too. I mean, people are definitely
Yeah.
interested in those.
Absolutely.
Clearly,
I
but
mean,
I get it.
Okay.
It all starts with yours.
Sure,
Right.
okay, all right.
Yeah, I'll definitely watch the planning board though,
Okay.
just to deal with the issue of intent.
Okay, I'll,
Because it's also notification, because my issue is, were the citizens notified? What did the citizens know in order to come? And obviously, I think
Sure.
they know, in the broader sense, everybody knows about these articles.
right,
I think it's pretty across the town at this point.
okay. Thank you.
One final procedural question. If 40 and 41 pass, which of the following articles can go forward?
Which can go for, so it depends.
After those two, if they
So
pass.
I
Yeah,
don't
none
know
of them.
what will be moved or not. So let's step back. When you have articles on the warrant, sometimes they're just not moved, right? So no
Right.
one makes a motion, or they move to, I forget what we do in Kingston, move to pass over or something like that.
We just don't move them.
We just don't move them, okay. So I'm not sure, and I can't speak for the planning board, whether or not they would move the article. And, so for example, 43.
I think my question is on another tack there.
Oh, yeah, sorry.
Can they move it if it's addressing a zoning bylaw that doesn't exist anymore?
Well, that's another,
Can basically Articles 42 to 45 be moved because they're looking to amend a zoning bylaw that now doesn't exist? If 40 passes. If 40 and 42 pass, then one, there's a prohibition under general, and now we have no zoning bylaw for it. So what he's saying is, can you amend something that doesn't exist? The normal protocol would be no. However, I am going to reread that. We're going to talk a little bit more about that, on whether or not you can or you can't.
because this question in that case is then scope, because everyone really has all the language.
Right.
The only questionable language is, it says to see if the town will And this is the tricky part, the amend, as opposed to when you're creating a new zoning bylaw, you say, to see if the town will add a new section, right? So.
Establish the zoning bylaw.
So, and we haven't decided that yet.
I want to read a few cases on that, just on the
Thanks.
difference between establish and amend,
Very good, thanks.
just to be a little bit more prepared on that.
Good evening. Dorothy Pat Harlow, 3 Pebble Lane, Kingston, Massachusetts. The question is to you. Will these articles be presented in numerical order?
40 to 45, the plan right now is that
Yes.
40 to 45 will be presented in numerical order, and they will go off at 7 o'clock on Tuesday night.
Thank you. Thank you
So that
very much.
everybody's aware that's going to happen at 7 o'clock. Yeah.
Oh, so that's important, not on Saturday. Not on
Correct.
Saturday.
Correct. We've
Not on
notified,
Saturday.
between the Board of Selectmen meetings, Elaine is the chair of the
Ah.
board at that point. It's been notified, it's been all the public hearings. I notified, so everybody's at Tuesday at 7.
Question. Let's say 40, 41 pass and, let's say 41 is, 40 is amended to prohibit it, okay? If it ends up being allowed. Does the Attorney General's office, when they look at whether or not the article is legal or not, would they look for the backup from the planning board on the posting of the public hearing? For them to determine, like, what backup needs to go along with the articles? Because I know it's more than just,
You mean if I rule the amendment within the 4 corners?
Yes.
The AG's office won't question that.
Yeah.
They'll say
they
that that
don't-
is moved appropriately.
yes, from your from your perspective.
No, I mean, as a law, then they'll take it up as this was an amended zoning bylaw as a prohibition.
Yeah.
Okay, so they
Yeah.
won't question whether or not it's been publicly noticed.
So I believe, and Elaine, I'll have to check this for you, and I'll have it for the certain answer on Tuesday, but I believe the Attorney General doesn't delve into that.
Okay.
They check to see if there's hearings and stuff like that, but they don't determine scope in terms of advertisement.
Okay.
I think where that arises and where we see case law is on appeals. If someone were to challenge the validity of the zoning bylaw, and you do that through 40A, a 40A appeal. So,
Okay.
yeah, pretty sure.
So let's say, for whatever reason, the prohibition isn't within the 4 corners. And we go to town meeting, and 40 eliminates the language in the zoning bylaw.
So 40 passes.
40
and there's
passes.
no zoning bylaw.
So in 41 passes, that means it's still 40, that the
So-
establishments can go wherever a typical retail store or something like that
So
could
the
go.
real risk is if 41, to be super clear, 40 and 41 both are successful. So they pass. The 40 passes with a 2/3 and the general bylaw and 41 pass with a majority. We would still submit it to the AG's office, and we would hope that she would approve it, but based on Brewster, there is a very strong possibility that she would disapprove the bylaw. If she disapproves the bylaw, then there would be no underlying zoning for marijuana uses. And then the marijuana retailers go where retailers go, and the marijuana cultivators would go likely in the industrial areas of town.
Okay, so the key to the prohibition on this is whether or not it fits within the 4 corners.
Yeah.
Because other than that, there's no
guarantee. So
Right,
usually
okay.
when you come out of town meeting, you feel very confident that the AG is going to approve. Here we have a real concern that she would not approve. And one important point, Elaine, I think that might be helpful to the folks at home and the folks here, is that, again, if there's no underlying zoning, it isn't, a free-for-all, and you would be in your residential neighborhood and you have a marijuana retailer. I don't want to make anyone feel overly anxious. It would be allowed in the business areas, and you're also left with that 500-foot default buffer, which is established by statute. So there is some comfort in knowing that if everything goes in a way that's not expected, that there's something.
But Kate, didn't the AG office throw out the zoning bylaw? I mean, in that case, the land court case, so if they didn't, they wouldn't allow our zoning bylaw either? So they wouldn't allow the article that just amended and prohibited and wiped out the zoning bylaw?
No. So what happened in that case was the zoning bylaw failed. The amendment to the zoning bylaw failed, and the general passed. And in the
I'm talking the land,
decision-
right, in the AG
land-
decision on the Brewster case.
Yeah. So in the AG's decision, the AG just disallowed the general bylaw. The zoning bylaw wasn't successful, I believe. I don't know.
I thought it was successful, but only with a majority vote.
Oh, let me
That
double
was the
check
problem with
that.
that case, is that it was successful, but it was a majority vote on a zoning bylaw. So
I
that
don't know.
added the twist on that case.
That is a twist,
Right.
yeah. So that could be it. I'm not sure. But regardless, there's that risk. But it's not, something that everyone has to run for the hills. If there is no underlying zoning, there are still protections in place by statute. Go ahead.
Bradford Randall. So on the Tuesday versus Saturday thing, just to be clear, the moderator would not accept a motion to take the articles out of order?
40 to 45?
Right.
Absolutely not. I will not. Correct. There's been too much publication to the citizens and expectation of when those articles will be heard.
Yeah. Okay.
Hi, Shepherd Long, 3 Gristmill Lane. I just want to make sure I'm understanding the 40 and 41 and how these all fit together. So what we're saying is, if we pass 40 as written, which just deletes any references to marijuana in the zoning, and 41, we could end up with the sort of free-for-all. So the alternative is to amend 40 on the floor to say, we're not deleting references to it, we are explicitly banning it under the zoning bylaw with a 2/3 majority. And then the question is, as the moderator, would you allow that sort of, that's a reasonable amendment on the floor as opposed to so wildly different that it doesn't fly?
Right, and if this came up, and
Is that a
it was the
pretty good
first,
summary?
right, exactly, and if this came up and it was the first ruling, my gut ruling is I wouldn't allow the amendment. But I now want to look at the planning board, I
Okay.
want to look at the notice that went out to the citizens in a broader sense to know whether or not the amendment would fit in within the four corners of the article.
Yeah, I mean, I understand there's,
I have a little more
to it
time now,
than-
so it's a little bit
Yeah,
better
it
in that
just,
sense.
as a layperson, saying that was clearly the intent of the original Article 40, and I wasn't at the planning board meetings, but it sounds like that was sort of
Right, that's why I just want to go
understood
back
be
and
the intent.
reread the cases on the
Yeah.
four corners, because there is, the issue is, what were the citizens notified about? And that's what it's all about, is
Yeah.
intent. So, and unfortunately, being a lawyer, the legal side kicks in immediately, and I say, oh, no, those are two different things. Repealing and adding a bylaw are two different things.
Yeah.
So that's why, I'm going to try to step away from the legal side and just read the intent part of the four
Because
corners.
I think what frustrates some people here is to be told that what happened at last town meeting was within the scope, and then to be told that this might not be within the scope is really hard to swallow.
Well, because I think the difference, just so everybody understands, is that when you have and you're trying to establish all of these bylaws, you can always say, let's get rid of them, because that's within the four corners. We're going to amend, do we amend with it all, or do we amend with nothing?
And
So,
then
yeah, it was
the-
a little bit of a shocker.
And then the only other thing I noticed, I was just looking at the little sort of one-sentence summary of Article 40 in the, in the warrant as published.
Yeah.
And it just says, to amend, I don't have it in front of me, but the little, I'm hoping that.
It says, sorry, I thought I had it.
This is a
and I lost
petition
it.
article to amend the zoning bylaw regulating marijuana retailers.
Right. Like if-
That wasn't written by David.
No, I
Yeah.
understand that, but I'm just saying, like, if David were to amend it on the floor to do what he wants to do, I think the summary would be the exact same. So we haven't really, changed what we told people we're here to talk about,
Yeah.
in my opinion, so.
Right, and it's going to come down to, he wrote the word delete
Right,
and not amend to prohibit.
Yeah.
So, I mean, again, it's all, some of it is semantics, yeah.
yeah, okay.
Thank you.
Hi, Holly Dyer. Just a quick question. Is it your sole discretion to decide whether it's in the four corners, the amendment, or is it possible to poll the residents as to what the intention was?
No.
Yeah, no.
She's the
Four
boss.
corners under the, actually, that's actually under the statute.
Yeah.
Whether or not any amendment made on the floor is within it is actually under the statute, that's only the moderator's power.
She's the boss.
Yeah.
Getting back to the four corners.
Mm-hmm.
Isn't this how we got into this mess in the beginning?
Four corners, sure.
And the
Last year's town
amendment,
meeting.
and the amendment was allowed.
Right, the amendment was made, it was voted, seconded, voted, and allowed, yeah.
So I'm just hoping that maybe that can follow suit.
Yeah, they're just two different things, though. That's the problem with it. But I think it's more important that I watch the planning board
Right,
meetings
absolutely.
to determine what was discussed. And if the word prohibition has been discussed and bantered at those meetings, then that might give me more weight that it was
Okay.
intent was that to prohibit.
Thank
I mean,
you.
I think we can say it in that sense, and I think in the general public, as opposed to lawyers, would look at it differently, too.
Well, and.
'Cause when
and
we say
I don't know
prohibit,
that
you-
we- Yeah.
Yeah.
I don't know when we've ever had town council honor us with going over our articles and tell us that, there are land court dealings and everything. This is unusual, to say the
Mm-hmm.
least. I'm not so sure that it's helpful either.
Well, these are all new laws. These are all new statutes and
Well,
legislature that went through.
exactly,
And
and
now we're
they've
getting, we're getting decisions that are now coming down. It's like when Alimony Reform Act went through. Everybody's horrible. We're just getting decisions on that now from the appeals court.
And
so-
precisely what I would say, once again, to people who are listening, this marijuana is all too new. Nobody knows what's going on with it. Our legislators put it through, and they didn't know. We don't even have police that can,
This is not procedural, this is on the merits of the question. I thought this meeting was
Okay,
discussing
then I will-
procedures.
Sure, I didn't call it, yeah.
Hi. So I have a question. So let's say 40 and 41 goes through, and then the AG says, no, this is not okay, it's not legal. So we've already had a town meeting, and what happens then? Do we revert back to the bylaw we have right now?
No.
that stand?
It's been repealed.
Because it would have been repealed.
So if
No, I mean, if the AG
To be honest with
says
you, I think
no.
what will happen is the Board of Selectmen will call a special town meeting in order to act and move for a zoning board of appeals. I would assume that what would be happening.
I don't think you understood my question. I said if the
both
AG
bylaws
knocks,
pass, yes, and there's
if
no
the-
reason why the AG wouldn't approve a bylaw amendment which says the town repeals its zoning bylaw relative to marijuana establishments. So we're not worried that that's at risk.
That's
So then it's
41.
deleted, it doesn't exist anymore. So what you have currently in the books is no longer there. And then if the AG were to then disapprove the general
The general,
bylaw
right.
under the reasons that we talked
Right.
about, then you just have if it's disapproved, you just have marijuana being allowed
Then
in
there's
the
no more
town of
prohibition.
Kingston-
Okay, got
Kingston,
it.
and it's not zoned by special permit.
okay.
Those are the consequences.
Can we, so who decides if we have if we rush to have a special town meeting? The Board of Selectmen? What if they just decide they don't want to do that?
Then would be a town with no zoning bylaws with marijuana in place.
So the BOS has that
Do
power?
you want to address that from the Board of Selectmen's view? You want to take this one and go from there, so you can address the people? Okay.
This is what happened last year when the moratorium prohibition.
It wasn't a moratorium.
It was a prohibition,
It's a
okay.
prohibition.
When the prohibition wasn't established at last year's town meeting, the Board of Selectmen immediately called for a special town meeting, and actually, I will admit, took some flack for that, for spending the money to do that. But we immediately did it because it was in the best interest of the town to have something in place, and that's when a bylaw was quickly put together. I would imagine if we're in that situation again, the current board would entertain the same approach, that we would have another special town meeting to put a zoning bylaw in place. We did it once before, so if history repeats itself, I would expect, like Janet said, that we would do that again.
But there's no guarantee, that's the trouble.
Correct.
Agreed. The best we can do is is to bring a recommendation to town meeting and then the floor decides.
Up, watch it.
Are there any other questions before we adjourn?
Hi, my name is Paul Brennan. I represent Alfred's Finest. We are one of the marijuana applicants in town. Based on everything that's been saying right now, if 41 or 40 passes, 41 gets rejected by the Attorney General, there's potentially going to be an emergency town meeting. If that's going to be the case, where is the town going to stand on where they currently are, whereas there has been a moratorium that was not allowed to be extended by the Attorney General, and there are now, I believe, 3 marijuana applicants in town, and the Board of Selectmen has said we're going to put a momentary freeze on issuing host community agreements until after the outcome of town meeting. All of these bylaw changes take up to 90 days for review by the Attorney General, have to come back if there's going to be an emergency town meeting. When does that happen? And where is the stance of where we get to move forward under state law? Because what would happen is, if there's no bylaw in place, it would refer to state law. Anybody not 500 feet from a K through 12 school would be legally allowed to apply for a license and then open in the town, potentially before any of this ruling comes back from the Attorney General. So would the Board of Selectmen then honor what I believe all 3 of us have now petitioned to appear before you at the earliest possible meeting following town meeting?
So what council was just saying too, Elaine, if you want, is that in order, if they were going to go call for a special, it would require, and that's why I just asked council, it requires 2 weeks to post for a planning board, to post the, to have a zoning bylaw hearing in front of the planning board, and then you need 2 weeks for town meeting. But technically, they can happen simultaneously, so a special town meeting could really be called within 3 weeks. 4 weeks probably at the outside latest.
So my question was, I guess,
You don't need a delay between the two. I'm sorry,
Just 1 week,
just to
yeah.
interject so these guys have a full picture. You don't need a delay between the two, provided the planning board sends its report to the town meeting. Then you don't have that 21-day lag.
And where,
Sorry.
so then where would the planning board actually be, the Board of Selectmen, where would you actually, your position be regarding the 3 applicants who are kind of waiting for the outcome of this meeting?
I'd like to be able to answer that, but I can't, to be honest with you. This is why we're having tonight, so we all can get educated and know what the steps are. I think what we would have to do is, after town meeting on Tuesday, see what we end up with. And then we're gonna have to make some quick decisions very quickly on what that looks like at the end of that session. And we know, we told you, after town meeting, the first meeting after town meeting, then we would entertain the host community agreements depending on the outcome of town meeting. So,
Okay, so if the next town Board of Selectmen meeting is only the following week after Tuesday's meeting, and there has been no emergency planning board or Board of Selectmen meeting to implement zoning bylaws, could any one of the marijuana companies move forward under state law, and would the town have to then legally look at state law and not be able to say, well, we don't know what's going to happen with zoning, we have to give you your license based on the law as it stands?
and that's what we have to have with council. I agree with you 100%. I know exactly where you're coming from, even based on what we have said as a board. But I don't know what it's going to look like after Tuesday.
I'm now thinking that it's in the town's best interest.
I don't want to make
Sure.
something up. And
Sure.
I'm going to throw something else out there that I was just talking to council about. I need to,
Wait.
1 second. And the zoning, then they're in conflict, and the zoning supersedes.
Oh, yeah, okay.
So that's what I'm
If
saying.
you're comfortable with that.
One of the things that I can do now, and that's what I was thinking when I was doing this, because what originally happened was when David, and I'm sorry, David, I forgot your, Cowing, sorry. when he filed his articles originally, he filed them with the general bylaw first and the zoning second. What happened in the procedural history, just so everybody understands, is then the Charlton case came down, and the Charlton case made the Board of Selectmen say, and Town Council and the Town Administrator say, we need to now flip these. So the Charlton case was the first one that came out, and that was saying that you need to have, you can't pass a general bylaw to prohibit something that the zoning bylaw allows. So that was Charlton on its basic. Now what happened was then the AG ruling on the Brewster town meeting and votes came out, and now this is almost changing what was going on with Charlton and why the town Board of Selectmen moved them so that the zoning would go first, because that's a 2/3 vote. And so the zoning would require, because if the zoning doesn't pass, and we end up with existing zoning bylaws, then technically 41 can't pass because it would conflict with it. And David and I had talked about that at one point. So when Charlton came out and they were saying, okay, now we need to do it, flip it, so that if the, if the generally, because if 41 passes, if that was number 40, and so the prohibition, the general bylaw prohibition passes, and then David's Article 41, or 40 now, the zoning bylaw article, I don't mean to confuse everybody, the zoning bylaw article then doesn't pass, because that's a 2/3 vote, so we're looking at two different standards here. If then the zoning bylaw doesn't pass, then we have we have a general bylaw that's a prohibition, and we have zoning bylaw that allows it. The zoning bylaws would supersede.
But at least
And they
we
would
have
protect.
underlying zoning.
So, because that's what the AG decision said, was that if you have conflicting laws, then the zoning bylaw is going to pass, is going to be the superseding, because it's a 2/3 majority vote. So the stricter and what to required greater votes will be the superseding statute or regulations, legislation. So what I'm just thinking as I'm running through all of this now again is that I think that it might behoove us to flip these back.
Yeah, I think she's right, because, I mean, what would happen is if the zoning ended up failing and you have a conflict, your prohibition is definitely not in effect anyway, but you would have had that risk regardless. Right. And then you might decide to just not move it or whatever, but you at least know what you're dealing with and have underlying zoning to handle marijuana. It's actually really smart move, yeah.
I'm just thinking to protect the town as well as to handle what is the notification. Okay. Because then if your article to prohibit marijuana doesn't pass, then now we have a general bylaw that allows it, and then we have a zoning. I'm assuming at that point, you're not going to repeal the zoning bylaw. Right. You won't move it. So now we'll go into the amended articles to amend the bylaw. To me, that makes sense, because otherwise, if we do it the other way, and your zoning bylaw does pass, because we won't get into why that might pass. If it does, if it passes, think of it this way, and I'm going to put it out there, might as well. If all of the marijuana distributors in this town that want to get a contract, they can all get all the people to vote yes on your zoning, abolish zoning, and then not prohibit marijuana. Now we have a town with no zoning bylaws, and they can be anywhere. Sure. So there could be a lot of reasons why people vote a zoning bylaw that would not be in the town's best interest. Okay. So I think it behooves us to put your articles back in the order that you originally had them in, the order that you submitted them in, which was the zoning, with general bylaw vote first, then the zoning bylaw. And those just got flipped. The Board of Selectmen did it, again, because of the Charlton case, and now we have Brewster that just literally came out.
Sure.
That's a good plan.
Obviously, we can talk about that privately tomorrow, too, but I'm thinking that might make more sense as I'm running these through, because part of this is to make sure that the intent is, I know you're not intending to, your intent of these articles was certainly not to have a free-for-all of marijuana in the town of Kingston.
Right.
So I think the intent would be that way.
Yeah, absolutely. And then just kind of as I was listening to you running through all this, just speaking back to the being able to amend that deletion into an actual prohibition, which was the intent. Absolutely. But just I was thinking as you were talking, I don't know when the deadline actually was to have this article submitted, January, February, and cases have come out since then. I mean, and this is such a rapidly evolving, judicial and legal and legislative matter. I mean, wouldn't that speak to the ability to be able to actually, amend it to kind of keep up with the, case law.
Yeah, the
and
Four
as we're
Corners
kinda
isn't
moving
about,
along.
the Four Corners isn't about keeping up with the case law or keeping up with the law. The Four Corners is about notice to the citizens. That's what's really, the intent behind the Four Corners is about notice to the citizens. That's why, I'll still look.
Yeah,
Because if
absolutely.
you can amend it, then amend it, that'll be great. You know what I mean?
Yeah.
I'll let you do that
Right.
if I can do that. I'm just gonna watch the planning board,
Yep, absolutely.
that. And then, but I think I'm just thinking about this, I might move it, and I will talk to you about moving those out in different
Sure.
order if I
Okay.
can't do the Four Corners.
Okay.
Yeah.
Thank you.
And so just to be clear, because Mrs. Harlow had said in the beginning,
Yes.
are you committing to going in
40, 41, 42,
40
yeah.
in actual succession? They will still be on Tuesday at 7, beginning with the marijuana articles, but we're just going to flip those two first articles. 40 becomes 41, and you understand.
Because the intent of the Board of Selectmen, when they did this, is always, our Board of Selectmen their intent is to protect the town of Kingston and to do what is best for the town of Kingston. So, with that, they originally flipped it to accommodate, and I know David I believe you were called about that at the time. I just lost where he is now. Okay, so I believe he was called about that, and so now I'm just thinking, with this, it just might make more sense to do it the other way. Yeah.
You can change the opening motion to go 41,
Right. So I have to do some quick thinking before Saturday, yeah. I just got to watch some planning board hearings.
That'll still be on Tuesday, though, if the opening motion passes.
Right.
Right.
But I need to move, right, correct.
Right.
But
we
they're not
need
going to be called out of
open-
order. I mean, that opening motion really is not going to, it doesn't matter. I'm committed, I do not believe that it would be appropriate or due process for those articles to be called out of order in order to fill a room and any of that. I just don't want that. That's not what this is about. Town meeting is about fairness and due process, and
Yeah.
that's why we're doing it that way. And I know everybody's like, well, why are these different? Because it's all new law, it's all this, and after last year with some changes and stuff, and people felt slight, let's just do it all above board, let's have it all heard when everybody can be there and doing all that, yep. Anything else? So, sorry, David, I will be in touch with you as the week develops, okay? Thank you.
We appreciate all you coming out. I hope this brought some clarity. I know it's a complex issue. Madam Moderator, thank you so much.
Thank you.
The Board of Selectmen, thank you for coordinating this. We appreciate it. Good night, folks. Thank you. Thank you.